Oyez, oyez, oyez. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. This is the April session of the Court of Criminal Appeals in Knoxville. The panel this morning is Judge Ross Dyer from Memphis, Judge Tim Easter from Franklin, and I am Norma McGee-Ogle from Sevierville. I think all of you know that you have 20 minutes per side. If you would like any time for rebuttal, please let me know before you begin your arguments. Mr. Kirk and Mr. Stone, I know that, as I understand it, Mr. Stone is going to primarily do the arguing. However you want to divide that up is fine with us, as long as you don't exceed.
Thank you, Your Honors. I'm Liddell Kirk, and I'm here to represent Nolandus Sims. And
I need
just a minute, Mr. Hibner needs to call the case.
State of Tennessee versus Andre Terry and Nolandus Sims.
Mr. Kirk.
Thank you, Your Honor. Good morning. I'm Liddell Kirk, and I'm here to represent Nolandus Sims. I'm going to argue, just reply to one argument that the state made in their brief, and rely primarily on the arguments that are in my brief. Then I'll yield the rest of my time to Mr. Stone to continue. The state had argued that primarily in my brief, I've argued about the gang evidence. I've argued about the sufficiency of especially the aggravated kidnapping. But with regard to the gang evidence in particular, I think the state argued that Mr. Slaughter, who represented Mr. Sims at trial, didn't properly preserve an objection to the testimony of Officer Thomas Walker. Thomas Walker testified as the state's gang expert, and his testimony was entirely about gang evidence. He was not a fact witness, unlike Mr. Marlin. His only purpose in being there was to testify about the gang evidence. But prior to the trial beginning in this case, on the day of trial, there was pre-trial argument where both defendants in the case objected to the state's use of gang evidence. They argued at that time, and the trial court didn't make a ruling then. The trial court wanted to hear more information and to begin the trial. The trial court indicated it would make a ruling later. But prior to the testimony of Mr. Marlin, who was the state's witness, and he testified prior to Mr. Walker, there was a jury out hearing where they again addressed gang evidence. And both defendants made arguments about the use of gang evidence, all gang evidence, and argued that it was unfairly prejudicial to admit gang evidence in this case. They made that argument then at that jury out hearing, and at that point, the trial court actually ruled on it. And I think the trial court's ruling in the transcript was around page 252 to 253. And the trial court at that time did make a ruling and said that the court was going to allow the state to use gang evidence in this case. So after the court made that ruling, the objection had been raised to the use of all gang evidence. The court had ruled on it. So there was nothing more that they were going to be able to argue when it came to Mr. Walker's testimony. Mr. Walker testified later, and his testimony was all gang evidence. There was no other reason to have him there. Mr. Marlin would have been a fact witness, even though he made references to gang activity and testified about gang evidence, but he would have been a fact witness regardless. Mr. Walker would not have been there at the trial, but for the court's ruling that gang evidence was going to be admitted in this case for the reasons that the court stated. So my argument is that the objection to the use of all gang evidence that occurred at the pretrial hearing on the day of trial, and also during the jury out hearing discussing Mr. Marlin's testimony, there was a general objection to the use of all of that, and the court ruled on it at that time. And the objection and the challenge to the use of all the gang evidence in this case was preserved during those arguments that occurred at those times during the course of the trial. And with that, the response, I'm going to rely primarily on arguments that are in my brief and yield the rest of my time to Mr. Stone. And I don't need any rebuttal time.
Thank you, Mr. Kirk. Mr. Stone? Mr. Stone?
You're muted.
Yes, my apologies, Your Honor. I was trying to note my time here to make sure I didn't run over. Good morning. My name is Wesley Stone. I do represent Andre Terry in this direct appeal. Mr. Kirk's argument regarding the gang evidence is an argument that we have also included as an issue in this direct appeal for Mr. Terry. we incorporate Mr. Kurt's argument today. We would also direct the court's attention to the technical record in this matter, which is volume 1, page 126. And that is where I filed on behalf of Mr. Terry a motion to exclude the evidence of the gang membership and gang activity. So we do.
Would you like any rebuttal time?
Yes, Your Honor. I was going to ask for 2 minutes in rebuttal, please.
Okay. I didn't want you to forget that.
Yes, I had a note here as well. And so we do incorporate Mr. Kurt's argument on that issue and also rely on our brief for that issue as well. I think the bigger issue and the first issue that we raised on behalf of Mr. Terry, Your Honor, relates to the jurisdiction of the criminal court, the trial court in this matter, because Mr. Terry, at the time of the alleged offenses in this matter, was a juvenile, and the state of Tennessee filed 2 petitions against Mr. Terry in the juvenile court for Knox County, alleging that he was a delinquent child as a result of the commission of the first-degree murder regarding Jack Hutchins, and also the attempted especially aggravated robbery as it relates to Larry Mathis. This transfer hearing was conducted by a lawyer judge, and it was conducted with 2 juveniles participating. The one juvenile was Quantavious Williams. The other juvenile was Mr. Terry. I think it's important for this issue that we start really with the fact that the argument that we made throughout the juvenile transfer hearing is the same argument that the state of Tennessee argued after Mr. Terry, along with Mr. Marlin, Mr. Sims, and Mr. Williams were indicted in criminal court, and that is that after Mr. Terry was transferred to criminal court, after Mr. Terry was indicted, the state of Tennessee filed a motion for a severance pursuant to Rule 14 of the Tennessee Rules of Criminal Procedure. And in our brief on page 22, we included an image of the actual wording that the state had alleged in that matter. And I think it's important for this issue that the court review that. And they allege that the state, by through the Knox County District Attorney General's office, moves this court for a severance of the above defendants pursuant to Tennessee Rules of Criminal Procedure Rule 14. Antonio Marlin made a statement to law enforcement which implicated the co-defendants, the crimes that took place on November 30th, 2013. Quantavious Williams made a statement to law enforcement which implicated the co-defendants, the crimes that took place on November 30th, 2013. Nolandus Sims made a statement to law enforcement which implicated the co-defendants, the crimes that took place, excuse me, on November 30th, 2013. The state went on to allege in this motion that the state is unable to redact these statements so as to violate Bruton. And while that's a typo, they were arguing that they did not want to violate Bruton, and they asked for a severance. And in that severance request, they asked that Nolandus Sims be tried first. However, Nolandus Sims and Mr. Terry were tried after Quantavious Williams had went to trial separately and apart from Mr. Terry and Mr. Sims. These words in this motion that the state filed are not our words, they're the state's words. They realized that they had a Bruton issue, and the purpose behind Bruton is grounded in the constitutional protections of Article 1, Section 9, and the Sixth Amendment of the United States Constitution regarding the right to confront and cross-examine witnesses. That's the foundation for that, because it would deny a person the right to confront and cross-examine witnesses if a statement by a co-defendant was introduced against that defendant at trial. If you take that further, and the Tennessee legislature, when it created the juvenile courts in the state of Tennessee, required that all transfer hearings be conducted in conformity with a certain set of statutory rules that we're all required across the state of Tennessee to follow. Included in that is the rule under Tennessee Code Annotated 37-1-127. And 37-1-127 has really 2 provisions that we've explained in our brief. The first part is subpart A, and it provides that a party is entitled to the opportunity to cross-examine adverse witnesses. And it also provides in subpart C of that statute that extrajudicial statements that would be constitutionally inadmissible in a criminal proceeding shall not be used against a child. So Rule 14, while it does not apply to juvenile court proceedings, it does apply to the criminal court proceedings, and that would be a criminal proceeding as we've set forth in our brief. And it is designed to preclude the admissibility of extrajudicial statements, particularly by co-defendants. Moving down to really the illustration, and I don't want to limit this argument, but we have set this forth in our brief. The statements that Detective Moran was allowed to testify to, made by Quantavious Williams. Quantavious Williams is the declarant. He did not take the witness stand, though during the transfer hearing, though the juvenile judge thought I could somehow ask him to take the witness stand in the transfer hearing. But Detective Moran was allowed, as part of that transfer hearing, to testify that Mr. Williams had told him that Mr. Terry was from Chattanooga, that Mr. Terry was part of the Rolling 20s, that they were here in Knoxville to induct Mr. Williams into the Rolling 20s, that Mr. Terry and others picked Mr. Williams, that when they picked up Andre Terry after later that evening, that Mr. Terry and others were excited that they were talking about the shooting, at which point Mr. Williams said to Mr. Moran, that Mr. Moran actually testified to at the preliminary hearing, that Mr. Terry was talking about the shooting of Mr. Jack Hutchins and how it was supposed to be a robbery, and that Mr. Terry shot Mr. Hutchins because he thought Mr. Hutchins was reaching for something in his truck. Mr. Moran was also allowed to testify to the statements at the transfer hearing by Mr. Williams that Mr. Terry, Mr. Bell, Mr. Marlin, and Mr. Sims came to Knox County to induct Mr. Williams into the Rolling 20s, that they were going around doing randoms, meaning random robberies, and that they committed a carjacking on an unarmed, unrelated alleged victim. Further, Mr. Moran was allowed to testify that Mr. Williams told him that Mr. Terry and Mr. Sims got out of the car with 380 handguns, and that after Mr. Williams and others circled the block, they saw a person laying in the street, bloody next to a truck. And further, yes.
I understand your argument about the statements of co-defendants, but for a transfer hearing, aren't we basically looking at a probable cause determination by the juvenile court? And if so, wasn't there other proof that would establish probable cause that he was involved in this crime and therefore allow for the transfer?
No, there was not other proof that there was.
There was no other witnesses that put him at the scene of the crime.
There was Mr. Diaz that said he saw a juvenile running from the scene that he originally thought was firecrackers, and that's what, when he went out to look, he thought that there were just some kids out shooting firecrackers. Other than that, no. And that's the only other evidence that you would have other than this testimony from Mr. Moran, that what Mr. Williams and Mr. Sims had told him.
Well, the state says that Mr. Diaz identified Mr. Terry from a photo array.
He did identify Mr. Terry as a person leaving the scene where they eventually found Mr. Hutchins, but Mr. Diaz did not see Mr. Terry shoot anybody. He did not see him with a firearm. He just saw his face running from a scene where they had heard some loud popping. And to answer the first part of that question, I disagree that transfer hearings are probable cause hearings. Those certainly are available in our general sessions courts. There's a whole set of rules that apply to that. But this is a statutory framework that when the state is seeking to try someone as an adult, that they have to follow, and that the transfer hearing has to be held in conformity with. I recognize that.
But the juvenile court judge just testified that he reasonably believes the individual is involved, that he needs to be held, and that there's not a mental issue that would preclude him from understanding his actions. So if it's just a reasonableness standard, and you have a witness who heard the gunshots, he may have called them firecrackers, but he heard the gunshots coming from the direction where the crime occurred. He saw the defendant running from that scene at the time the crime occurred. What else do we need to put him at that scene? And therefore, a reasonable standard.
The constitutional and statutory safeguards that are provided by Article 1, Section 9 of the Sixth Amendment of the United States Constitution, and the obligations that the decision of a juvenile judge to find reasonable grounds has to be based on the statutes that the transfer hearing is conducted in conformity with 37-1-127 and some other statutes, meaning the ability to confront and cross-examine witnesses against them, and also to not permit the introduction of inadmissible evidence that would not be admissible in a criminal proceeding. So I recognize that those three standards do exist, but it's the foundation upon which the judge can make that decision. What would be any different, rhetorically, I guess, for lack of better words, would to just let Mr. Williams' statement play, let Mr. Sims' statements play, and we have no opportunity to cross-examine those witnesses during the transfer hearing. So it's our position that while there is a reasonable ground standard that applies in the statute, that those standards have to be in conformity with other statutes and the constitutional protections that's afforded to everybody. So it's our position that, and there was an attempt by the state during the transfer hearing to make the argument that it was a kind of like a preliminary hearing. They tried to introduce an autopsy report under 5.1 of the rules of criminal procedure. And we objected, and that was not introduced. There was no autopsy report that was introduced during the transfer hearing. And I believe that probably takes me into a little bit of my rebuttal time. So with that, we would ask that the court reverse based upon our brief, and we rely on the other arguments in our brief.
If my clock is right, you have about 6 minutes left.
Okay. Well then, thank you, Judge. I apologize. I had misnoted that. So it goes on, and to answer Judge Dyer's questions, Mr. Sims was permitted through Mr. Moran to testify that they were driving around doing randoms, that Mr. Sims and Mr. Terry got out of the vehicle. They approached Mr. Hutchins, that Mr. Terry pointed his gun at Mr. Hutchins first, and then when he reached into the truck, Mr. Sims, through Mr. Moran, was allowed to testify that, or Mr. Moran was allowed to testify that Mr. Sims shot Mr. Terry shot Mr. Hutchins when he was reaching into his truck. And then further in the transfer hearing, Mr. Moran, over objection, was allowed to testify that Mr. Sims told him that Mr. Terry entered the rest of his gun into Mr. Hutchins, and then they left the scene. So, speaking to the prejudice issue, the juvenile judge did base its decision in large part on the hearsay statements, the extrajudicial statements of Mr. Sims and Mr. Williams, and it stated in part, when it was addressing the issues, whether the offense was committed, this is the juvenile court's words, whether the offense was committed aggravated, aggressive, in a premeditated manner. The juvenile court said yes. When you hunt somebody to rob and jump out of a car with a gun, that's an aggressive and as premeditated as it can get. The juvenile judge went on in making this decision to say that because of the heinous acts and cold-blooded murder that was testified to in the case of Mr. Terry, that was testified that Mr. Terry ran from the victim's scene, eyewitness. I don't believe that a young man that jumps out of a car and shoots another man, I believe he is beyond the juvenile court's ability to rehabilitate at the age of 16. His loyalty to the roll 20 is not to himself. Further that, he's in the gang, maybe high up in the gang. I don't know how much about the structure. So clearly, the juvenile judge is basing his decision in transferring Mr. Terry to the criminal court on the statements that were introduced through Mr. Moran. And I think it's important at this point to pause just a second, because during the transfer hearing, the state tried to introduce the extrajudicial statements of Nolandus Sims. And Judge Irwin, the juvenile judge, said, "I am tired of hearing about remote witnesses in this case," and refused to allow Mr. Moran to testify as to what Mr. Sims had told Detective Moran. So here again, going back to the issue is that during the transfer hearing, by statute and constitutionally, Mr. Terry had the right to confront and cross-examine witnesses against him. This includes Mr. Williams. This would include Mr. Sims. And because he was denied that right to do that, the transfer for hearing pursuant to 37-134 was not conducted in conformity with the 37-127. And I come back now to what Judge McGee said at the trial court when it was entertaining the state's motion to sever in the criminal court. Judge McGee said it would be terribly, horribly prejudicial to Mr. Terry, and it would violate his confrontation rights as his right to confront the witnesses, because Mr. Williams would not necessarily take the stand in his own trial. So what was used as a basis to sever these defendants in the criminal court upon the state's motion was denied to exclude this evidence from being entertained by the juvenile judge. So it's our position that the transfer hearing was not conducted in conformity. It deprived the criminal court of its jurisdiction, and we had taken this issue up on an interlocutory appeal to this court. This court said it would wait until this time to address this, and so we asked this court to grant that relief in our brief. I do think probably I would like to wait at this point to address any of the issues that Ms. Redding has on behalf of the state in my rebuttal. And so,
Mr. Stone, let me ask you this, because I kind of got lost in some of this. Did the state move to sever all of these defendants in the criminal court?
yes.
And at some point, did they change their position on that? Because Terry and Sims wound up being tried together.
That's exactly right. And that position was never really fully stated, and it does not appear in the record. It just happened that way. As you can tell from the motion that the state filed for severance, they asked that Mr. Sims be tried first. Then they flipped Antonio Marlin. He testified against Mr. Williams and testified against Mr. Sims and Mr. Terry, and Mr. Sims and Mr. Terry were tried together, which really goes into the issues that we had raised during the trial, that we had moved for a severance during the trial based on the fact that they were introducing some of Mr. Sims' statements now that implicated, at least indirectly, Mr. Terry in this joint trial.
And I noticed in your brief, this is maybe out of curiosity, you cite a case, State of Tennessee versus Andre Terry. Is that your client?
Yes, that is the case where we had filed a motion to dismiss in the trial court in front of Judge McGee, asserting these same issues that we're raising here. Judge McGee denied that motion. We asked Judge McGee to give us permission to take a Rule 9 interlocutory appeal to this court.
Mm-hmm.
This court decided that it would wait until the trial occurred and then address this issue on direct appeal.
So that's just an order that we put down saying, bring it back up when you do your direct appeal.
That is correct. That is correct. But this is not the first time this court has actually seen this issue, and I wanted to bring that, in this particular case, I wanted to bring that to the attention to the court as part of our argument.
The decision in Mr. Williams' case has already been decided.
Yes, I think that this court put that down maybe earlier this month, maybe April 4th or April 6th, and I reviewed that opinion, yes, generally.
Thank you, Mr. Stone.
Thank you, Judge.
General Redding?
Thank you. May I please support Catherine Redding on behalf of the state? I will first address Defendant Sims' argument for claiming that he did preserve and raise the 404B issue on appeal. The state would agree that Defendant Defendant Terry filed a motion in limine, and the trial court did hold a hearing on a motion in limine. That motion asked just to exclude gang evidence as pretty general. Defendant Sims did not file his own motion in limine or move to join Terry's motion in limine. At the 404B hearing, Detective Walker's testimony about the history and nature of the Crips was not discussed. The trial court did not rule on the admissibility of that particular evidence. That is really the subject of Mr. Sims' appeal. And when Detective Walker testified at trial, specifically about the history and nature of the Crips, Sims did not object, neither did Defendant Terry. or take any action to ensure that the trial court actually ruled on the admissibility of that particular part of Detective Walker's testimony. To ensure that there was a ruling on it. The trial court had not had an opportunity to hear this testimony before the 404B hearing. So by failing to contemporaneously object at the trial, there was never a ruling from the trial court about this particular part of Detective Walker's testimony. And as to defendant Terry, the state has argued that he's waived any claims regarding Detective Walker's testimony, and that argument is just to point out to this court that defendant Terry has not raised any arguments in his brief specifically about the history and nature of the Crips. His claim on appeal is that the trial court erred by omitting evidence of his gang membership and the fact that there are different divisions of the Crips, specifically the rolling 20s and the rolling 40s. But his brief does not get into this history and nature of the Crips the way that defendant Sims does. So the state is arguing that defendant Terry has waived any objections to that particular part of Detective Walker's testimony. I believe that addresses the 404B issue. The state will rest on its brief as to the merits of the 404B claims. Moving to the defendant Terry's argument regarding jurisdiction, the trial court properly denied defendant Terry's motion to dismiss. First, the defendant is not entitled to appellate review of transfer proceedings. The statute
anywhere. I mean, when a juvenile is transferred to an adult court, there's no appeal from that. Is that the state's argument?
The state's argument is that their statute does not allow for an appeal of that. The statute makes a distinction between transfer hearings where the juvenile court judge is a lawyer and where he's not. So,
but if the juvenile judge is a lawyer and transfers a juvenile to adult court, that is not appealable to any court.
Not under the statute as it is written. So the state has reviewed transfer hearings from a lawyer juvenile court judge under Griffin, and the process for all the cases that I've been able to find where the court has reviewed a juvenile transfer hearing relies on Griffin. But in Griffin, that court reached its conclusion that surely a transfer proceedings where the judge was a lawyer must be appealable without looking at the analyzing precedent, legislative history, or other authority. It just simply said, we believe that there must be a way to have this reviewed. And so it said you can have it reviewed either by pleading not guilty during the trial, raising it on appeal, or by pleading guilty and raising it in a certified question. But because in Griffin, the court couldn't actually determine whether the juvenile court judge was a lawyer, whether it was a non-lawyer, and eventually held the defendant waived appellate review because he pled guilty without reserving certified question. The court's pronouncement that a juvenile court transfer proceeding can be appealed, reviewed on appeal with dictum. But sorry, what's my office? Even if a transfer order issued by a lawyer juvenile court judge is appealable, the defendant also is not entitled to relief because transfer in this case was mandatory. And how we see the Tennessee Supreme Court said that transfer to criminal court is subject to a juvenile court's discretion unless the 3 factors that are set forth in TPA 37.1, 134A4 are found by the juvenile court. The Sixth Circuit has affirmed this concept, stating that transfer is mandatory if those 3 statutory factors are satisfied. So here, when the juvenile court found reasonable grounds to believe that the defendant Terry committed the delinquent act as alleged, that he wasn't committable to an institution, and that the interest of the community required him to put under legal restraint and discipline, transfer to criminal court was mandatory. But third, even if the court were to find that the transfer order is appealable and it's reviewable for abuse of discretion, the defendant is not entitled to relief because juvenile court's alleged errors were harmless. as Judge Dyer mentioned, a transfer hearing is essentially a probable cause hearing. The defect in the probable cause hearing generally has no consequence unless the defendant is prejudiced by it. As the court explained in Hensley, because the transfer hearing, the transfer order, and the case were followed by a grand jury determination of probable cause and a return of an indictment, and a testimonial defect at the transfer hearing was cured. And even if the juvenile court did err by admitting investigating Moran and Detective Walker's challenged testimony, that error was harmless because there was other admissible evidence on which the court could find reasonable grounds to believe the defendant committed the delinquent act as alleged. Jerome Diaz testified at the transfer hearing that he lived down the street from Mr. Hutchins. Instead of denied the defense, he heard talking noises, he opened his front door, he saw two males running away from the vicinity of Hutchins' residence. Basically, Mr. Hutchins lived around the corner and he saw the defendant, he saw these two males running from the area, from the street where Mr. Hutchins lived, past his front door. Diaz testified that one of the males looked straight at him as he ran past, and he did identify that male as Terry, in a photographic lineup and at the transfer hearing. And Diaz testified that when he went to Hutchins' residence, immediately after seeing these two males running by, he saw that Mr. Hutchins had been shot in the head. The record supports the trial court, or the juvenile court concluded that this testimony alone was sufficient for a finding for reasonable grounds to believe that Terry was murdered. Because there were reasonable grounds, because all three of those elements under 137.1, 134.84 were met, the juvenile court properly transferred defendant Terry to criminal court. The criminal court had jurisdiction to hear this case, and defendant Terry is not entitled to relief.
Does 134.84 involve some type of testimony about disabilities or mentally ill?
So under that statute, the three factors are that there are reasonable grounds to believe the child committed the delinquent act as alleged, that the child is not committable to an institution, which goes into the mental abilities, capabilities of the child. And third is that the interest of the community require the child to be put under legal restraint or discipline. So
I couldn't understand you on that last one. Could you say that again, please?
I think we need to make sure that defense counsel can hear plainly.
Are you having trouble, Judge Ogle?
I am.
Understanding you, General.
Well, the three grounds are reasonable grounds to believe the child committed the delinquent act as alleged, the child was not committable to an institution, and the third is that the interest of the community required the child to be put under legal restraint or discipline.
And at this transfer hearing, there was testimony about all of that.
There was limited, most of the testimony dealt with whether the child committed the delinquent act as charged. I can't say that I recall too much testimony about the other factors. I mean, the defendant didn't put on any proof to show that he should be committed to an institution rather than being sent to criminal court. And certainly the court could find reasonable ground from Mr. Diaz's testimony about the victim being shot in the head and the defendant's participation that this kind of crime required, the community had an interest in having the defendant be put under legal restraint or discipline. But the proof focused primarily on the delinquent acts rather than a question of committing the defendant to some sort of institution. I will briefly touch on the severance issue that the defendant Terry has raised. Defendant Terry waived this claim by failing to make a motion to sever before trial. Under the Tennessee Rules of Criminal Procedure, a defendant's motion for severance of defendants has to be made before trial unless it's based on a ground not previously known. A defendant waives severance if the motion is not timely. Here, the defendant did not make a motion to sever the defendants before trial. In fact,
But they did, correct?
Yes, the state filed a motion to sever the co-defendants based on potential difficulty in redacting their statements. And defendant Terry opposed the motion. He said, well, no, you chose to indict us together. We have to stay together. You cannot have no standing to invoke a right to speedy trial or to protect our rights. So, and you chose to indict us together, and we must remain, or we're required to remain together. And my understanding from the record was that the trial court denied the state's motion. Mr. Williams went to trial on his own, and the opinion was recently issued by this court in Mr. Williams' case.
Is there an order that addresses that?
I have to look back at the record. I thought that my recollection is there is, but obviously the court, it's in the record. I know Mr. Williams had his own trial. So my recollection is the court denied the state's motion, but I would suggest that the record will provide more accurate information. My recollection is not entire. I don't want to rely on my recollection at this moment. But I do know that the defendant has waived this. He fought vigorously to keep the co-defendants together. And the new grounds exception to the pre-trial filing requirement doesn't apply here because defendant Terry knew that Sims had made a statement to law enforcement. I mean, that was mentioned in the state's brief, the state's motion to sever. But regardless of waiver, defendant Terry is not entitled to relief on this claim. The trial court admitted into evidence a highly redacted recording of Sims' police statement, which did not refer to Mr. Terry. The complained of term they was used by investigator Moran, and to the extent that they can be understood to refer to Terry and implicate him in the offenses, those implications came from investigator Moran, and defendant Terry was allowed to cross-examine investigator Moran. And on this record, there's no Bruton issue and there's no error from the trial court's refusal to sever the defendants. And so if there are no further questions, the state will rely on its brief as to the issues that defense counsel has not raised.
But when we look at the record, we will find a motion where the state requested that these defendants be severed, correct?
Yes.
And at some point you changed your position on that?
My recollection is the trial court denied the motion. The state asked that they be severed and the court said no. As to defendant Terry and Sims. My recollection is that he said, yes, Williams gets his own trial, but Terry and Sims have to stay together.
Okay.
If there are no further questions, I ask that you affirm the judgment of the Knox County Court. Thank you.
Thank you. Mr. Stone, you have your 2 minutes.
Thank you, Your Honor. To address Judge Easter's question, the motion that the state filed can be found at volume 1, page 70 of the technical record. Number 2, I'm the only one present today that actually participated in that particular hearing, and we all left there believing that we were all going to receive 4 separate trials. So with that said, the idea that we tried this case with Sims and Terry together was something that was not known leading up to this particular trial. And I would point out that we have stated in our brief that the redacted statement that the state is speaking of now was filed as a late filed exhibit. So it appears that redacted statement of Nolandus Sims was a statement that was kind of put together on the eve of trial, or maybe even during that particular trial. But I think it's important.
Was there any objection made or issue raised when you discovered, if I'm understanding you correctly, you thought everyone was going to have separate trials?
Yes.
You realize that really was not the way it was going.
Your Honor, I couldn't I don't recall specifically at this particular point, but when we did, and based on the state's original motion to sever, if you go back and review Rule 14C, there are 3 options that the state has to choose from. And so if the state's trying us together, it's safe for us to presume that subpart B would play a role in here, that you would have to make the redactions or not have the particular statement come in at all. And I think it's also important on this issue that those statements, while there are references to the state's theory in this case was criminal responsibility for the conduct of another. And so while they were saying, we don't necessarily know who the shooter was, each one of these individuals were responsible for the conduct of the other, then that by implication, and we cited it in our reply brief, that you can breach Bruton by implication. So the minute that they started getting into the issues of these statements by Mr. Sims at trial, we started moving for severance and moved throughout the trial of this case for a severance. Would respond briefly to the state's argument that any prejudice that Mr. Terry suffered by being transferred from juvenile court to the criminal court was harmless. As the court's aware, a juvenile court only has the ability to extend jurisdiction over a child up until their 19th birthday, which means they can hardware secure juveniles up until the age of 19. However, when you transfer a juvenile from juvenile court and subject them to a trial and a conviction and sentence for first-degree premeditated murder, then now they are looking at 60 years at 100%. And we submit to this court that there was clearly prejudice to Mr. Terry as a result of being transferred based upon the unconstitutional extrajudicial statements that were introduced during his trial or transfer hearing. So with that, we ask the court to reverse the judgments, remand for a new trial or dismissal.
Thank you.
Thank you.
That concludes this case. Mr. Clerk, we are ready for court to be recessed.
This honorable court is now in recess until 11 a.m.